Welcome to Trial Think, the podcast of Kenney and Sams. In each episode, our team of nationally recognized litigators and industry experts discuss how the lessons they learned before, during, and after trial can be used to reverse engineer best practices for attorneys, clients, and risk managers.
Welcome to Trial Think, the podcast of Kenney and Sams. I'm your host, Nate Cole. I'm one of the three shareholders with the firm. I've been in the civil litigation and construction litigation practice for about 17 years. And joining us today are the founders of Kenney and Sams, Chris Kenney and Mike Sams. Thanks for being here today, guys.
Thanks, Nate. Thanks for having us.
Thank you, Nate.
Chris, I've known you going on now 10 years. I've been with the firm for about 7 years. You and I met when we were up against each other as opposing counsel. How did you and Mike meet?
How did we meet? Mike and I met, over 30 years ago when I was a junior associate at a Boston law firm and he was being recruited as a summer associate, and we immediately hit it off. I then left that firm, went to another firm. We stayed in touch loosely as friends, but it wasn't until I started another law firm that I said, I want to recruit a great lawyer, and I reached out to Mike.
Well, that's kind, Chris. A funny little story, Nate. I did ultimately join that firm that Chris was talking about, where he had started as an associate. By the time I joined, Chris had just left, had been recruited away by another firm in town. But by coincidence, I ended up working with the same administrative assistant that had worked with Chris. And it had probably been working there about a year, and I'd had some trial success as a young lawyer. I was fortunate to get some opportunities. And I remember after winning a trial, she says, "Oh my goodness, you're going to be the next Chris Kenney."
High praise, high praise.
We've stayed in touch, absolutely, absolutely.
When I met Chris, I was handed a file. I was an associate at the time, and the partner gave me the file and said, "Do you know Chris Kenney?" I said, "No, I've heard the name." He goes, "Well, you're not going to push him around." I said, "We'll see about that." But here we are 10 years later. I wouldn't say that I pushed him around, but as you do often in civil litigation, I made a real good friend as an opposing attorney. Our clients didn't get along, but we did. And we had a real healthy respect for one another. And then years later, Chris called me one day and said, "I'd like you to meet my partner, Mike Sams." And here we are now. Mike, why don't you tell us a little bit about your background? You've been in practice for longer than me. What do you do, and what is your specialty?
Sure, Nate, thanks. Yeah, I've been practicing up on 30 years now. Hard to believe. Civil trial lawyer. I'm capable, and we have tried all different types of matters, from personal injury defense work to a windmill case down on the Cape. My practice is much more focused in the construction arena now. It's by happenstance. That's how my practice and clients developed. But the construction law work that I do and that the firm does runs the gamut, from drafting and negotiating contracts to helping construction clients with risk issues when they come up on a job, frankly trying to keep them out of litigation, to putting on risk management programs for them, to when they need it, being their fighter, being their champion in the courtroom or at arbitration and trying cases for them.
Okay. Chris, your reputation preceded you when it came to Mike and I getting to know you, but why don't you tell our listeners what got you started in the practice of law, what's your specialty, and what have you been doing since you graduated law school many years ago?
Thanks, Nate. When I was in law school, I thought I wanted to become a real estate lawyer. I had a job working with Boston Properties, which is an outstanding commercial real estate firm. And then in law school, I joined the legal aid clinic and got a chance to be licensed as a 303 lawyer, get into housing court and help people in real cases under the supervision of a licensed lawyer. And I got the bug. And I joke with that lawyer who got me introduced to litigation that he saved me from a life of riches as a real estate lawyer. But I was made to be a litigator. I've always enjoyed competitive sports, and litigation is a competitive undertaking for sure. There are rules. You have to follow the rules. Rules of procedure, rules of evidence, rules of professional responsibility. So you play within the rules, but you definitely play to win. None of our clients hire us to come in second. And I've just always been invigorated by the process of litigation and the event of trial.
When did you start Kenney and Sams with Mike, Chris?
We started in 2006. Mike and I were partners at a fine firm in Boston that we enjoyed very much. But we approached things a little bit differently. We were both trial lawyers, and this firm had a robust commercial real estate and business practice. And I remember meeting Mike for a beer once and saying, wouldn't it be great if we could have a firm where we did things the way we want to do them? Not that it's right or wrong, but it's our way of doing things, and it works for us, and we enjoy it. And we started to think, well, why don't we do that? We both had young families and might have seemed a little bit reckless, but we were blessed to both have married women who believed in us, and we made a plan, and we took a flyer on it back almost 20 years ago now, and we've been very fortunate to build a great team and a firm we're very proud of.
Mike, you were both at successful, established Boston law firms. I understand that you wanted to go about things maybe your own way, and knowing you guys, I understand that. You've got a pretty clear vision, but was there an entrepreneurial streak, or what made you decide to take the big chance to start your own firm as opposed to maybe finding a firm that was a better fit for your respective practices?
That's a good question, Nate. There definitely was a bit of the entrepreneurial bug, I think, in both me and Chris. And we realized it just is, working together all those years, we got to be friends. We shared a vision not only of how we handle cases, but just talking about life and business. And we both came to realize that we had that bug, the bug to do our own thing and grow our own business, sort of the American dream type of thing that you hear about. Of course, from my perspective, Chris might have been more knowledgeable about it than I was. From my perspective, I didn't know what I didn't know. And some people will say, geez, you had to be so brave to do something like that. I think a lot of it was, some of it maybe was bravery, some of it was just not knowing exactly what it entailed before we dove into it, but we've been really fortunate.
How did you know that you would have the ability to run a company, right? We're lawyers. I don't believe either of you went to business school, but Chris, what gave you the confidence that you would be able to actually run a company with employees and grow it the way that you have?
I was fortunate at the firm we worked at previously. I was a member of the management committee, so I was familiar with the HR perspective, the budgeting perspective, and some of the nuts and bolts of running a law firm. Certainly didn't have an MBA or professed to be an expert in business administration, but we found that we take the basics of business and then we would inject our trademark enthusiasm and excitement, and that's really what helped fuel the business. The other thing is we knew, as Mike said, what we didn't know, and so we hired office managers and accountants and insurance professionals to advise us. We're smart enough to listen and learn, and we don't dabble in areas we don't know about.
How big, Mike, was the firm when you and Chris started? It was just the two of you, or did you have some other folks that joined with you?
We had 4 lawyers when we started and 2 administrative support folks who were all terrific. But it really was it was a new thing. We had found a nice building where we could sublet some space, but Nate, when we were interviewing people, they would come in at 6 o'clock at night. Because we were still working full time, and we'd have people come in at 6 o'clock at night into the space. Only when they came into the space, I remember there was this big cloth that was dropped down from the ceiling, more of a plastic bag to hold the dust from the other side where the construction was going on. So people would walk into our space and they'd have to pull aside the cloth or the plastic trash bag just to get through and meet with us. And in looking back on it, I think, what must have those people have thought? And maybe that's why some people, when they came in, maybe turned around and went back out the door before they ever came in and met with us. But it certainly was humble beginnings. A fun
Pay
start.
no attention to the man behind the curtain.
Well, so that curtain was 18 years ago. We've come full circle, and now we've got a firm in our office here in Southborough. The Southborough location, we also have a Boston location, has big plastic bags down the end of the hallway because we're in the middle of a big expansion. We've got construction going on now. Did you have a plan when you started the firm with a few lawyers and the two of you that it would grow to the size of the firm that it is now?
It wasn't necessarily a plan. Mike, I think we wanted to have controlled growth and be able to get big enough to be taken seriously and to handle larger cases. We're 24 lawyers now, and I don't know that we ever aspired to be that size, but we've grown in as a matter of necessity. We've been lucky to have good clients and good cases, and therefore we've had to attract good lawyers to help us build those. And over the last 18 years, we've grown as our demands have dictated.
Yeah, I second that, Nate. I would just say, as I remember back having some conversations about this, and we made a educated decision not to bring in partners from other practice areas, not because we don't value that area of work, but because it's not areas where we're experts. We made the consistent, educated decision not to try to make ourselves experts in those areas, but rather to develop relationships with outstanding lawyers in other firms who work in other practice areas, such that we can refer clients when clients have needs outside of where we practice. What we were really focused on was just being the best trial law and risk management firm that we could ever be, a firm that people would think of when they needed somebody to help them, whether it's risk management or trial or arbitration work. And we sort of thought, as Chris said, once we could get to a size where we would be big enough to take on whatever size matter somebody might have had, everything else from there is just going to be however it is that the practice develops. And we've been fortunate to not only have our practices develop, but to have partners, good folks like you, whose practices have developed and required the growth and adding to the firm.
Yeah, I want to speak to you more in a bit about the things like trial practice and risk management and what that means for our firm and how that informs the way we practice. But Mike, if you would speak a bit more, you mentioned we're up to 24 lawyers. It started with just a couple some 18 years ago. Can you speak more to what Kenney and Sams is now? Describe what we are as a firm and what we're doing in 2024.
Yeah, we are always trying to be not only a great firm, but the very best trial law and risk management firm that there is. We always want to be up at the top when people are thinking about who am I going to hire to fight for me, to defend me, to get me a result, whether that's a particular party or a business representative that they're friendly with who refers us in. We want to be at the top of people's minds, not just because we know people, but because we achieve results. And so we have some practices that we follow to help us maximize the opportunity to achieve those successes, whether it's Trial Think or the way we approach communications with our clients, that we think help separate us from other firms. But at the end of the day, what we're always aspiring to be, Nate, is the best that we can be. And we think we've come a long way. There's other good firms out there for sure, and we're always trying to get in and be at the top.
So we're going to look under the hood and sort of see some of the protocols and the approaches that you all have instituted and that have worked for the firm to be able to get us to the level we're at. But Chris, let me ask you this. What do you think distinguishes Kenney and Sams from competitors? We're in Massachusetts, a lot of great lawyers. We encounter great litigators all the time. And in fact, I prefer to go head to head against a real good contemporary that can advocate for their client the way that we do. But what would you say distinguishes a Kenney and Sams attorney from one of our competitors out there?
I'd say it's our unique approach to attacking every case. As you know, we call that approach Trial Think. And the name arose from general discussions when we were fleshing out the vision of this law firm about how do we develop cases with an eye toward how we win it at trial. Now, of course, not every civil case goes to trial. But that's the point. If you prepare the cases for success at trial, you're more likely to have a favorable resolution before trial. And so we did that, Nate, as you know, and the Trial Think approach starts with the intake. When a new matter comes into the law firm here, it is reviewed by 24 lawyers within the first week, because we have a weekly case review process every Monday morning at 8 a.m. It's a command performance. All the lawyers participate. We used to do it all in person before COVID. Now we have it all by a Teams meeting. And any new matter that came in the preceding week, it will be vetted. So there's a case summary presented by normally the senior associate running the case with the partner. And then, through that summary, someone will jump in and say, who's opposing counsel? I know her. What's the issue? I've got a brief on that. Who's the judge? I know her well. This is her approach to evidence. And so we'll roundtable these cases, just the new ones as they come in, on a weekly basis. We do this on our time and at our expense. The clients don't pay for it. But it gives us a running start on every new case, not just to be reactive like, hey, there's a complaint, we have to file an answer, but rather, hey, there's a complaint. What are the causes of action of the complaint? What are each of the elements of that cause of action? Who has the burden of proof on the complaint and then on the affirmative defenses we assert in our answer? We go through all of this, trying to look down the road and look around the corner so that we're not being reactive in our approach, we're being proactive. And it's proven to be very effective for us.
Yeah, it's a different way of doing things than other firms I've been at, where a lot of those case review meetings, you'd sit down as a firm, you may look ahead at what the next 2 weeks entailed in terms of coverage for depositions or other hearings. But at Kenney and Sams, and we'll speak to this idea of trial think, our case review at the beginning of each week is really substantive. We have all the lawyers in the firm getting together, and case by case as they come in, the new cases for that week, we dive in with a lot of deep knowledge. So you have the benefit of the 20-something lawyers on that call, and they're kicking around all different ideas. And that's a major distinction between the way that we do things and the way that other folks do things. But trial think itself, this term and the name of the podcast, when we started the idea of a Kenney and Sams podcast, thinking we have these great conversations within the firm that we find really valuable, we think other people listening in would find valuable, and that I think our clients would appreciate understanding how we tackle each one of their cases. We decided to do the podcast, and the three of us got together and thought it would be a great idea. And then we were trying to find a title. And so we had a sort of search committee, and we went all around with these different ideas, but ultimately didn't come up with Trial Think. I can't take credit for that because the two of you had trademarked the term, in fact. Isn't that true, Mike?
Yeah, we did back maybe a decade ago. And I think it was born, Nate, out of these the case reviews that Chris was talking about that we have every Monday, and following from those more specific meetings with the trial team at the beginning of the case. And I think it was Chris who said something to the effect of, well, let's put some trial think on it. And we started talking about that in the context of, let's look at where the case would end up. But let's not wait until we get there to adjust to where it ends up. Let's think about, based on the facts and the law, as we understand it, based on the info we have right now, where it's likely to go, and work our way back from there. Where do we want it to be? And let's work our way back from there as to how we get there. And we called that Trial Think.
Yeah, it kind of organically became the perfect name for what we're trying to accomplish in the podcast, right? And this idea of reverse engineering cases, because there's so many things that can happen in a litigation, but with all of our experiences, we're able to get a better sense of where things are going to go. And rather than wait till we're already there or we're figuring out in real time, I think a nice thing the firm does, certainly for its clients that want to stay out of litigation, is be able to use our experience and advice to avoid it through Trial Think. So let's talk a little bit back to where Chris was getting into the Monday morning case review. We're going over these aspects of a case that are going to inform how we go about it. Chris, what percentage of cases actually go to trial? We use the term Trial Think, but it's not all about what we're going to do once we get there, right?
That's right. Yeah, for sure. I mean, the statistics show that well over 90% of civil lawsuits that are filed in a court do not go to trial. They resolve either through a motion to dismiss, a motion for summary judgment, or most frequently, a settlement. And the settlement is mutual compromise, reduced to a contract, and the case is over. The value that Trial Think brings to that process is that the negotiation, of course, is just an interpersonal human exercise. So whichever side has leverage, whichever side can demonstrate that it's going to be prepared for victory at trial if the case doesn't settle, is in a better position to settle. So our Trial Think approach prepares the case for trial, but really, as a byproduct of it, it helps us to get into position to win the case at mediation. I know that sounds like an oxymoron, but we do have the concept. We try to win cases at mediation. What we mean by that is we get a result that matches our client's objective at the client's budget. That's a win at mediation. We approach mediation much like we do a trial. We advocate. Some firms like to go to mediation and then just have the mediator go back and forth with numbers. That's not the way we do things. We advocate. We have an opening statement. We have excerpts of expert witness reports. We may have the key exhibits blown up. And it's not designed to be a dog and pony show. That's sort of a cheap term. It's designed to promote well-informed decision-making, both for our client and for the opposing side. Sometimes the opposing side has never had an opportunity to see us present our case. It's always been filtered through their own attorney, through his or her reports to the client. So mediation is a chance for us to use Trial Think to try to get the case resolved on the best terms possible. When we say win, what we mean is our client is pleased with the outcome for a variety of reasons. Maybe it's the monetary component of it. Perhaps it's the confidentiality provision. We represent a lot of high-profile individuals that, value their privacy and confidentiality. We represent businesses that can't afford to have bad news, like a bad judgment across the front page of the Boston Globe. All of these objectives can be achieved through using our Trial Think approach.
With the Trial Think approach, let me ask you this: is it something that can be used on any case, regardless of the relative costs? I mean, if you've got a case and we are fighting over millions of dollars, and we have clients that hire us to do that, all of this pre-trial work and the running down every issue, it's economically viable for the client. But is it an approach that makes sense for any case, or is it reserved for the big ones? Mike, what do you think about that?
Yeah, I think it's I think it's the approach you should take on any size matter, because if you start with the client's goals in mind, what is the win for the client in the case, and then you work backwards, it requires you to think through mechanically what you intend to do. And then you can think about and size that, Nate, to answer your question, to the particular matter. And sometimes it allows you to realize, I don't think this is sizable. I don't think that what the clients come to us with, an important issue perhaps, it can't be done. It can't be done in the way that maybe we normally would. And so that requires a conversation with the client to maybe help them make a better decision as to what their end goal really is, or to further refine the steps you're going to take. That is, what we have found is meandering through a case without a plan. And maybe that's hard charging through a case without a plan. It takes you a lot longer to get to where you would want to be, and can also allow the other side to make moves that otherwise they wouldn't make. It's a lot more costly way to do it. So, long-winded way of saying, it works. It's something you should do in any case, no matter how big the case is, to help figure out what the plan is. Is that plan sizable for what the client needs done?
Yeah, this idea of sort of digging in early and coming out prepared, demonstrating you're ready to go to trial. I think what we're saying is that when you do that, you give the client a lot of other options, including potential early exit ramps if it's just not going to be a viable case to take all the way to trial. But someone said to me recently, Chris, there's a difference between a litigator and a trial lawyer. We consider ourselves trial lawyers. What is the difference in your mind?
Litigators take simple concepts and make them impossible to understand. Trial lawyers take complex situations and make them relatable and understandable. So there is a real difference. The knock on litigators from almost every client I've ever talked with is, they're told at the outset, we've got a great case, let's do this, let's do that. And then, a lot of money's spent, trial date comes up, and the litigator calls the client saying, we've got a terrible case, you have to write a big check to get rid of this. We can never go to trial. That's not fair to the client, right? And that lawyer should not be retained again. Our job is to help them from the outset to make well-informed decisions. So, our practice, as you know, Nate, is to try to make sure that there's a retainer up front that allows us to front load a lot of the work, the analysis, perhaps bringing the experts on early. And our promise to the client is that this front loading approach is going to help them to make a better decision earlier in the case, which ultimately saves money. Sometimes the realization is you don't have a great case. And our job in that instance is to tell the client about the weaknesses and then tell them how we shore them up, or how we get to a mediation and get this case resolved on better terms than if we went forward to trial. For example, every case has evidentiary issues, and we front load those to say, we think we have a good case, these are the issues we want to present to the jury, but then you look at the evidentiary standards. Some of these may not come in. It might be hearsay. Perhaps it's not authenticated. We didn't meet the chain of custody. So these things that we think are great at the outset, if they're not really fully analyzed up front, you're going on the false notion that you have a strong case when you find out through summary judgment or motions in limine that all these golden nuggets are lead. So again, that's part of the trial think approach, is to front load some of the hard, deep thinking, some of the candid conversations with the clients, where hopefully we're delivering great news, but if there's bad news to be delivered, we should deliver it up front while they still have a chance to steer the direction of the case and the budget for the case.
Yeah, that idea of, I think it's the collective experience of the firm allows us at the beginning of a case. I mean, literally sometimes before it comes in, we're roundtabling it, certainly that first week when it comes in, and we're able to say, here are the potential problems, here are the solutions, here's how we go and find the answers to those problems. But oftentimes it's the solution is advising a client early, you've got exposure, you've got a weaker case than you may have thought, here's why, here's how we're going to position it strongly going forward. But you need to be able to advise the client in a way that their eyes are wide open to what's coming. Because I often will say to clients, here's what it's going to cost to win the case, right? There's a big expense that you have to take into account. Never mind if it doesn't go the direction that we want it to go. But Chris, you talked earlier about winning, and winning is it's a relative term when you're dealing with clients in litigation. How do you define winning, and how can it be different for client A versus client B in what you've seen over the years?
It depends what the client's objective is. You know, in breach of contract cases and personal injury cases, it's about compensatory damages. You know, the client feels like she's been wronged and she wants to be put in the same place she would have been if she had not been wronged. So it's about chasing the money. In other cases, you know, where say a wrongful death case or a racial discrimination case, there's a whole other psychological element at play, and the prospect for not just compensatory damages but punitive damages. It's a different animal entirely. So winning depends on the context of what you're fighting about and what the upside and downside risks are of going to trial. Again, you know, if you are the plaintiff, it's about making sure that you're vindicated, you get compensated, and perhaps, you know, perhaps people throw this word around, but there is a principle at stake. You know, for a business, you're enforcing a non-competition agreement, you're enforcing a patent, whatever it is that's the most important. To achieve that win, you could go to trial and win and get a judgment, or you could find that after you prove that you're going to win, you're able to negotiate a settlement that results in a contract that contains releases or licenses to use the product, for example. Whatever it is you want to achieve, there's often more than one way to skin the cat. Our job is to make as many of those avenues available to the client to choose from in a menu of options, rather than being stuck with just being forced to go to trial with the upside and downside risk.
Mike, I remember Mike early on. I want to turn this over to you I want to raise a point. Early on, Mike, when I worked at the firm, we put a lien on property for a steel subcontractor, a fabricator, and it wasn't over a lot of money, relatively speaking. And we pushed aggressively. And I remember going to you and asking, why are we pushing so hard and incurring these fees for what seemed to be a relatively small amount of money? But we were aggressive and we pushed. We ended up getting the client 100 cents on the dollar, and the client was thrilled and brought you and I up to the facility. And it was an important moment for me because he said, you know, I understand the bigger picture, and there need to be some of these loss leaders, because I need the world to know that I've got aggressive lawyers, whether it's over 50,000 or 500,000 or bigger. I need the world to know that I'm going to fight over this money. Do you see that a lot with your clients, that there's this principle, but it's not just principle in a traditional sense, but really a smart business move to have lawyers come in that are going to aggressively fight and go after money that they're owed or push back when they're pushed around?
I think that there's a benefit to aggression on most cases, Nate, but that comes again with the assessment through Trial Think. That is, you know, when you approach a case, you can approach it from a perspective of running someone over, or trying to run around them, or realizing that you need to actually collaborate with the other side to try to get to the best end result. Being prepared to be aggressive, though, gains the client confidence. That is, if they're in litigation, most of them want to know that they've got a champion. You know, sometimes some of them think about it as sort of having a big brother out there fighting for them. When they have that confidence that you're capable of doing that, you're willing to do it, and that you want to in the right circumstance. They're also more capable of hearing you when you're talking to them about maybe alternatives. That is, Chris said we want to put a menu of options whenever it's possible in front of the client. Helping them make good decisions on that menu of options comes from them trusting you, comes from them knowing that you're willing to be aggressive and willing to fight. But they call us trial lawyers and counselors at law. And a lot of what we have to do is counsel them based on the facts and the law to help them make a good decision on what the win is. And the win may very well be exactly what they want it to be when they come to see us. But it may be circumstantially, whether based on some difficult facts or some bad law out there, that the win is a little bit different than what they might understand that it is when they first come to see you. Getting them to understand that and make good decisions comes about, though, as a result of a lot of communications and founded on their confidence that you're not scared. That when you're talking to them about what the win is, if it's slightly different from what they came to see you thinking that the win is, it's founded on trust of you, which again comes from knowing you're not running from a fight. You're just trying to help them.
And how often have we seen, even in the last year, the firm being brought in at the very last minute as trial counsel? A case is going to trial, it may have been worked up by a litigator for a couple of years, and all of a sudden they realize they're not ready, and they may be scared of what it means to try a case. And we come in and we apply Trial Think sometimes later in the process than we would prefer, but we're able to jump in and push it over the finish line and be able to actually try that case because we do it as a firm. Winning is different things, Chris, and you mentioned earlier some of the other factors that go into evaluating the likelihood of a win. We start that at case review, but things like the county where a case is brought, opposing counsel, the judge, how do those factors matter, and how do you work them into Trial Think when you're evaluating what a case looks like to advise a client on where this thing is going to go with all of these variables that we can't predict to 100% certainty?
That's a great question, and it's frankly a consumer protection issue because not all lawyers are equal. And what I mean by that is, I should never be handling an intellectual property case or a tax case. I'm not an expert in that area. I shouldn't dabble. We stay in the area that we have expertise in. But you see opposing counsel in cases, and we do due diligence. We drill down on our opponents and on the opposing parties. We know as much about them as possible. We don't wait for a deposition to find out what they're all about. When we find out that we're up against a worthy trial lawyer who's got experience and she's been in court before, that adds value to her case. Our client should know that they are up against an experienced lawyer, and that levels the playing field. Conversely, if we know that it's somebody that is not a match for the case, that's something that may factor in the client's willingness to go to trial and risk at a trial. So it's really important up front, as you know we do it at the very first meeting, is who's the judge assigned to the case? Who's opposing counsel? Who's co-defendants? Among the co-defendants, is there a chance for an alliance, or are we going to be pointing the fingers at each other? All of these dynamics are like stratego. I mean, there are things you've got to think about up front because they add value or take value from the case.
That's how I see Trial Think. You've got so many variables as a counselor, as a litigator, as ultimately a trial lawyer, and a client's trying to ask you to predict the future. And I'd say I can see around one corner, maybe two. It's really hard to see around 3 or 4, let alone to see what 12 strangers are going to do with your case in 2 years. So I view it, Trial Think, as eliminating variables so that we can make it so that the world of decisions throughout the course of a litigation are as narrow as possible. That's our job, to try and narrow it. Mike, when you come across, and you're thinking this way of Trial Think, and you're trying to eliminate variables, and you're trying to read the other side and size them up, what's your feeling on when you see on the other side of that docket, you get a complaint or someone answers a complaint, you see another lawyer. Do you like to see a lawyer that you think they're not going to be able to keep up with Kenney and Sams, or do you prefer a lawyer that you've worked with in the past that you know can operate at a high level, or does it change on a case-to-case basis? Because it's something that I think about a lot and have advised clients on. You don't always want necessarily a bad lawyer on the other side of the case. That could make it more expensive for you. But what are your thoughts on that?
I think it depends on the circumstances, Nate. If we have a very strong case and there's a really capable lawyer on the other side, there's different reasons why that is good. One of them, maybe foremost, is you're counting on the fact that they're assessing the case, whether they admit it to you or not. They're assessing the case in the way that you are and where it's likely to go. And you know them to be a good lawyer, then you know that that lawyer will advise his or her client appropriately behind the scenes to reach a better result.
On that point, it's almost counterintuitive, right? You're banking on the fact that if you can show that this case has problems for the other side, a good lawyer is hopefully going to see that and be able to advise their client accordingly. Sometimes we have the strongest cases in the world, but if you've got a lawyer on the other side that just doesn't get it, they're not going to be able to appreciate it, and they're not going to in turn be able to tell their client what they're up against. Do you see that's a major factor that you see with some frequency?
Yeah, that can be a practical issue for sure. It can also result in a breakdown of avenues to get to a resolution. For instance, you're bringing a case against another party, and what you'd like for them to do is be able to trigger their insurance, and the insurance company on their side is declining coverage. If they could only trigger some coverage, it'll lead to a faster resolution of things, depending on what the facts are. It is helpful to have a good lawyer on the other side who knows how to make the right arguments to trigger the insurance, to get the insurance company involved, to bring things to potentially bring things to a speedier, more fulsome resolution. Conversely, if you have a lawyer who just doesn't have the experience in the area, sometimes even if you're reading them the playbook on how to do it, they have a harder time getting there. Yeah, just as an aside too, as a professional, it's fun to try cases and battle with really terrific lawyers on the other side. And we're fortunate in Massachusetts. There are some really terrific lawyers that we get to do battle with on the other side. So from a selfish perspective, I do enjoy having the talented lawyer on the other side.
Yeah, certainly. The three of us spend a lot of time in various bar organizations and know how many great lawyers, great people that are out there representing folks in the Commonwealth. So we have a high degree of respect, but you're nevertheless going to come across some lawyers that may be out of their depth in terms of their experience. They may just not be in the right area, or any other reason why we may feel that we're better positioned to push against them. But that's one of the factors that we face as trial lawyers. Chris, you talked about the high percentage of cases that settle, and that's a factor that we know that a lot of cases are going to settle. We know the overwhelming majority of litigations end up settling. How do you deal with, in your career, having tried a number of cases, many, more than a lot of the more junior lawyers will ever get to try now because of the changing dynamics of the cost of trial and the way that it works, but someone with your experience, how have you dealt with the roller coaster of, is it going to settle, is it going to go to trial, and always having to prep as though it's going to go the distance?
The best way to approach it is to follow the schedule slavishly. As you know, when a lawsuit's filed, the tracking order is created by the court's computer system. It sets deadlines for different phases of the case. But that really takes you up to the pretrial conference. That's showtime. If the case is going to settle, the judge is going to press forward to the pretrial, and if it doesn't settle there, you're going to get a trial date, and now you have this window of maybe 4 to 12 weeks to get this case ready to put on to a bunch of strangers for disposition. That requires a whole new schedule, because in that intensive period, you've got to have your trial team ready to divide up different tasks and make sure that this case that's going to trial is the highest priority in your practice right then. And of course, all your cases are important, so we've got to make sure that we're talking to other team members to make sure that nothing falls through the cracks on any other case while we're focused on showtime in the case that's going to trial. It can be a roller coaster, you're right. The roller coaster is aggravated substantially if this planning is not done, because the other cases blow up, they take you away from trial prep. You need to have a team approach where you are addressing everything in the practice with the triage approach of saying, right now, this case is the most important because it's going to trial imminently.
Mike, do you have a spidey sense when a case comes in, this one's going to go to trial, or this is one that could make it? Do you see that early on, or is it one of those things that you approach every case like it goes to trial, you're always ready for it, and then it's the luck of the draw? Or are there signals, are there types of clients types of factors that you see that point towards this thing's headed to trial?
You know what, Nate? I think I just try to assume every case is going to go to trial. Now, I recognize, 95, 98% ultimately don't. But I really do assume every one is going to go, because I think if you start thinking this one might not go, you can also get off of track and get away from trial think, because you're thinking, man, this thing's going to resolve. I don't really have to approach it the same way with the same discipline and the same vigor. And the ones that you don't prepare for, I think you can ask some other people out there. Those are the ones that end up going. I think you have the best opportunity to get the best result when you assume it's going to go for trial, you prepare like it's going to go for trial, the other side realizes that you're ready to go to trial, that you're fully capable of trying a successful case, they're much more apt to resolve the case. So I actually think, being more prepared and aggressively pushing the case increases the likelihood that it's going to resolve itself.
Certainly. We've seen that as a firm, and it's a good reason to prepare early and often and explain to the client why that upfront cost is going to save them money over the long run. If you're not prepared and you're not willing to put in the resources early, it's eventually going to catch up to you, and then that becomes more expensive when we're not able to do things efficiently and preemptively. Chris, you past president of the Mass Bar Association, you are in touch with judges. What if anything is being done in the Commonwealth to try and help junior lawyers get trial experience and have more cases go to trial? Is that an issue that the courts are aware of?
It is, and I commend the state and federal courts for passing standing orders that encourage law firms to give junior lawyers opportunities to argue motions and to participate in trials. This is really innovative because it steps a little bit into the trial process, which is supposed to be about protecting the litigant's rights. Because if you entrusted a matter to a junior lawyer rather than having the senior partner handle it, if something goes wrong, it could be a real problem for the case and for the client. To guard against that, the courts have built in a safeguard saying, if Nate Cole, a senior trial lawyer, has a case with a junior litigator and is going to let him, the junior litigator, take a witness, the safeguard might be the judge will say, although I normally have one lawyer handle each witness, I will allow you, Attorney Cole, to step in if you think there's any cleanup to do when your colleague is finished. So, that just protects the client's interest. It's really not allowing two bites at the apple because they're not going to let you just do a whole new examination. But the courts have been very good partners with the bar in trying to get younger lawyers more opportunities to actually learn how to try cases.
It's a good point. We do it as a firm. We're able to have the lawyers at a junior level involved with prepping for depositions, start to take their own depositions and understand how important the way you phrase a deposition question is. We explain it, and we know that ultimately a deposition question is creating a transcript for impeachment purposes. It's not just to get that information. It really is to have that witness locked down in such an efficient, effective way that when it goes to trial, you can use it to box them in and cross them. And to be able to see that in action really informs the way that junior lawyers practice every aspect of their jobs. If they don't see what the discovery is going to be used for, if they don't see why the exact wording of a deposition question is important, and see how you can think you've got that right answer, and then you go to cross somebody at trial and it's not as good as you thought in the transcript, then you lose it. That's really important. You both talked about risk management, and I want to get back to that because it's a term that we throw around as lawyers at Kenney and Sams, and I understand we contrast it with litigation. But Mike, what's risk management, and how is it different than litigating a case all the way through trial?
Well, there certainly are elements of risk management in cases too. But when I'm thinking about risk management, I'm thinking about it in a couple specific contexts where we do a lot of work, and that is in the construction law area and in the employment law area. So it is the idea of getting out in front of potential issues to minimize the chance that they come back to bite you in the rear end down the road. So for instance, on the construction end, it is, we do it in a couple of different ways. One, for clients, we will go out and put on risk management presentations to them, updating them on legal issues. So construction, over the last couple of years, the prompt pay law has been an issue. To just having discussions and presentations for them on contract and payment risk Another area is we actually help them with their contracts. We'll draft contracts, we'll negotiate contracts. And then the other area of construction risk management is the blips that come up on jobs. Construction is about as complex a thing as you can do. My goodness, my hat's off to the industry. I'm always amazed by what they can do. But as good as the tradespeople are performing the task, issues come up. A design issue, maybe it looks great on paper, it doesn't flesh out well in the field, or something just doesn't get done right. And then the issue is, or maybe the allegation is one of the parties isn't behaving correctly under the contract, and the issue is, what do you do? And so clients will call us on in all of those areas, and we'll work with them to try to get to something acceptable to minimize the chance as much as we can that they have to be involved in trials when they otherwise wouldn't. That is, as risk managers, we're working hard to keep people out of trial, out of litigation, because we recognize that clients that litigate more than they have to, they end up spending too much of their financial capital on it, and they spend too much of their human capital on it instead of developing and investing in the business, or developing and investing in lawsuits, which is not good for them. So we work hard on the construction risk management end. Same thing on the employment end. I'm not an employment lawyer, but we've got 3 or 4 partners here who do almost exclusively employment law work. And it's largely, or not maybe, it is heavily in the area of risk management. That is doing the same thing, but on the employment side, keeping clients up to date on what is transpiring in the employment law end of things so that clients know what they're supposed to be doing by way of SOPs, helping them with employment handbooks, and helping them try to separate from employees without stepping in it along the way. All of those sorts of things to minimize the chance that they have to be involved in litigation.
Nate, the value of an ounce of prevention and how important that is to spend that money up front. Chris, go ahead. I interrupted.
Excuse me. Yeah, I was going to say this is part of Trial Think too, really, because when we finish up a matter for our clients, if it was a litigation matter, we had a phone call, something has happened, and we go in, the facts are established, we do the best we can to get the best result in that case, but then we meet with the client. Case is over, and we reverse engineer it with cold objectivity to make sure that we can address what caused that lawsuit to erupt in the first place and change it so it doesn't repeat itself. That's part of Trial Think too, which is, we put this one fire out, but let's think about, could this repeat itself? Churchill said those who fail to learn the lessons of history are doomed to repeat them. We make sure that our clients learn the lessons from the case that we just help them resolve so that it doesn't repeat itself. That might mean you're changing an employee handbook, you're training personnel, you're getting defective equipment out of use, whatever it may be. And it's worked well for us because we find that the relationship we have with the client to handle a matter now becomes a counseling relationship where they look to us for sort of outside general counsel advice. And if we're totally successful in that risk management exercise, we'll put ourselves out of business as litigators because we're helping them to avoid those risks.
There's a question for both of you. The idea of risk management, reverse engineering, Trial Think really as a concept, it does involve the experience of having seen a case all the way through. How do you find the challenge of training junior lawyers to be able to use and deploy Trial Think and risk management when they haven't necessarily had that full experience? What are the sort of the protocols or the day-to-day things that have worked for the firm to get the junior folks in a position where they can counsel and advocate and be able to lawyer the way that we expect folks to be able to do it at Kenney and Sams?
Well, I'd say, Nate, it's a tough process. Not everybody is built or inclined to do or want to do what we do. We're blessed to have a terrific team, including a terrific team of younger lawyers who are fully engaged and want to blossom into being trial lawyers and accept what that means, the angst of taking on somebody's problems and having to figure out how to solve them, the angst of having to answer to partners on what's the result, how do we get the result, what's your plan, and having to think it through. So we're blessed to have to be surrounded by a great team in that regard. To get them trained up, it's a time-consuming process experientially, and there's a lot to it. So as Chris mentioned, we've got case review every Monday. by being actively engaged and present for case review, they get to hear not only colleagues of their generation and experience levels talking about how they've accomplished certain things, but also some maybe some pearls of wisdom from some of us from an older generation who have had more decades doing it on how we've accomplished it. So simply case review, week after week after week. I mean, you picture we've got 52 of them during the course of a year. That's a lot of training built in right there. We also do a lot of internal training, whether it's on trial practice training. One of our partners, Dave Kerrigan, led a trial practices program in-house today. We've got internal trainings at least once a month, whether it is in a trial practices area, so actually a how-to on a particular item at trial, or how to take a deposition, or how to handle a motion. We have in-house construction law training program once a month, focusing on different contract issues, different way to attack trial issues related to a construction law element. To finally, as they gain this experience and show the capabilities, that they get to progress from not only answering interrogatories and responding to requests for production of documents, but to sitting in and then taking depositions and defending depositions. I think we've got 3 different depositions going on today, each being handled by a different associate, whether taking or defending. But that doesn't happen overnight. It all comes from this time-consuming process of being part of case review, of being part of internal education, and we're big proponents of external education as well. We've been involved, different of our partners have been involved in MCLE, Mass Continuing Legal Education, for years, putting on programs, and we see the value of organizations like that, and the MBA and Mass DLA, and we send the lawyers to different programs that those different bar organizations put on for external training as well.
Yeah, that sort of apprenticeship model, I think we all naturally like to mentor. We like to share what we've learned. And we've talked about it in the past that we were all really fortunate to have great mentors in earlier parts of our career. So we can't say enough about that. We're getting towards the end, and I'm going to talk a little bit about what's to come. I want to thank you guys both for joining us today. But I've got a couple of questions as part of the Trial Think Tank, a little segment we do at the end of the podcast. Chris, let me start with you. Best advice you've been given to be an effective trial lawyer?
To build your case so that you can candidly say to the opposing lawyer, we can do this the hard way or the easy way, you choose. And what I mean by that is litigation is a contact sport, and it can be expensive. And our clients are not well served if we're just running around in a pugnacious mode trying to prove how tough we are. Litigation is not an ego contest. But we have to have built our case strongly enough that, as Mike said, if we've got a good lawyer on the other side, you can have a conversation with him or her and say, this is the way I see the case. If you want to go through and see what a mediator thinks of it, let's do that. I'm all for it early on. Let's see if we can get it resolved. But if your client insists on going through the whole litigation process and having a trial on it next year, we can do that too. Letting them know that we are reasonable, experienced lawyers who will advise our clients well, will never be rolled over, but we're not gratuitously nasty either. So we can do this the hard way or the easy way, you choose.
Mike, that's the advice that Chris has received and been happy to get over the years. What's advice that you like to give to junior lawyers or other folks that join the firm from Mike Sams? What are your words of wisdom to others that you found to be effective?
I think there's 2 significant pieces that I try to live by in addition to what Chris was just saying, and some of these overlap a little bit. One of them is, I used to hear lawyers say, the facts determine who's going to win the case. And although in its essence, that's a true statement, what I found is the lawyers who master the facts first are the ones who typically win the case. You understand the strengths, you understand the weaknesses before the other side. You can attack on your strengths and try to paste over your weaknesses before the other side recognizes them to exist. As an aside, if you're good at doing that, mastering the facts before the other side, you should also probably realize when your case position is at its zenith so that you can recommend to the client, now is a good time for us to get out of this one. The other really big piece, Nate, and I know Chris subscribes to this too, is we have to be the best at communicating with our clients. I think there's a lot of great lawyers out there, but there's also a lot of lawyers out there who don't connect with their clients, and they don't connect with their clients simply because they're not communicating well. And that comes in two forms. Either they're not communicating often, such that the client understands the plan and then getting updates on how the plan is progressing, in which case the client thinks, I don't know what's going on, and they don't have confidence in you, or they think you're not doing something. They think you've just forgotten about them, you don't care about them. The other thing that happens is if you're not communicating with the client can't be in a position of consenting to what your exact plan is and understanding why it is you're doing X, Y, and Z. So for me, it's about mastering the facts and communicating well with the client so you know the client is on board with the plan and the client is educated on what the facts are and what the law is and what's driving the case.
Yeah, and the way you communicate, something that we may take for granted, but I'll say over the years that I've been here, I've picked up on the verbiage, the words, the way to explain what's going on to a client, the way to make a client understand that they're in good hands. And one of the things we try to share with the junior folks, the newer lawyers, or even senior lawyers that have been doing it successfully at other firms, is this idea that you've got to be communicating before someone's asking what's going on. If they're asking, that's almost by definition too late. Of course, it's aspirational, and there are times that someone's going to check in, but you really want to be ahead of where the client is so that they know you're worrying about their problems so they don't have to. Because otherwise you're a vendor, you're an expense, but you're not viewed as a real partner with the client, taking those problems off their plate. And then the other part I think is really important that I think we do well, and that it's part of Trial Think, because what ends in a trial, it really is so critical to start earlier, is the way that you can communicate with a certain attitude, a certain enthusiasm, and not just to come to a client identifying problems. That is a big part of the job, right? Probably the most important part. We talk about the clients aren't hiring us to be their cheerleaders, but rather to identify the problems, but most importantly, to then come up with a solution. It's not just to say this is bad. It's here's the issue, here's how we're going to fix it. And that mentality really is what Trial Think is all about. And it leans heavily into the idea of collaboration, being at a firm like Kenney and Sams where we like each other, we work together, taking all that experience and reverse engineering it is a phrase that we've thrown around today, and ultimately being able to see where things are going, maybe not around 5 or 6 corners, but a couple of corners ahead, so that you can always keep the client in the loop and make an informed decision. So I appreciate everyone's time here today. Thanks to both of you. It was great to hear the origin story of Trial Think and what it means. In the coming weeks, as Kenney and Sams rolls out additional podcasts, we're going to be exploring all of the areas that the firm excels in. Construction litigation, business litigation, partnership disputes, employment law, construction risk management. These are things that we do as a group really well. You're going to hear from guests that are internal to the firm and also outside guests come in and join us. But ultimately, the bigger part you're going to understand is the theme of Trial Think. And maybe that's the biggest takeaway, is that on Monday morning, when we get a new case in, we are thinking thematically. What's this going to be about? How's the jury going to hear this? How's this witness going to come across? And that theme of Trial Think will work its way through the theme of the upcoming podcast. So I want to thank all of our listeners for joining us. Thank you, Chris. Thank you, Mike. Appreciate it, and look forward to sharing additional thoughts on how we practice law and what Trial Think is for Kenney and Sams.
Thanks, Nate.
Thanks, Nate.
Thank you.
Thanks for listening to Trial Think. Don't forget to like, subscribe, and join us for all of our upcoming episodes.